This is a course, if you want, or a seminar in trust litigation. If I were writing a no contest clause in a original trust agreement, and then I wanted it to be there, and I had discussed it specifically with my client, I would include a new word-for-word no contest clause in the First Amendment. Notwithstanding, if you get the case on your desk, whether the no contest clause is going to apply to that First Amendment, then frankly, I would rather have the argument that incorporates by reference does work. And real quickly, the Perrin case says this: we do not mean to say that a trust amendment could never be drafted in such a manner as to clearly incorporate a no contest clause contained in the original trust instrument, thereby making the no contest clause applicable to a challenge to the amendment. So it's dicta, right? Because the court says that ratifies and confirms isn't the same as incorporation by reference. Also, keep in mind something that occurred to me as I was going over my notes for today, so things keep popping up. Keep in mind that the concept of an incorporation by reference does not depend on the concept that the trust agreement and the First Amendment are one instrument. And to the contrary, the incorporation by reference actually depends on the concept that they are two different instruments, because one instrument, the First Amendment, is incorporating by reference a different instrument. Otherwise, you wouldn't have an incorporation by reference. So that's one other thing to keep in mind. Secondly, Probate Code Section 6130 clearly says, expressly says, that a incorporation by reference can be done in a will. And as we know, policy reasons suggest that wills and trusts should be alike, but for whatever reason, we don't have the same statute in the no contest clause area for trust agreements, but it is there for wills, so keep a note on that. And then finally, the Law Revision Commission, when it came out with the new statute, said that an incorporation by reference should work. So I think those three reasons, I'd rather have my case. Maybe we'll have it someday, John.
Well, the court did not accept the 6130 argument in Rossi.
They were wrong.